Hey everyone, thank you so much for coming today. My name is Fiona and I work in the Alumni Relations Department here at Reed College. We are especially honored to have Bear with us today, sponsored by the Portland Alumni Chapter and the Presidential Council on Campus Climate. So thanks for coming, and I'm going to leave you with Amanda here, Amanda Waldrop, class of 2007, who is the chair of the Portland Alumni Chapter.
Thank you. Thank you. My name is Amanda Waldrop, and as Fiona said, I graduated in 2007, and I currently volunteer for Reed as the chair of the Portland Alumni Chapter. And I have to say that speaking in Ballroom Lecture Hall has been on my bucket list for a number of years, so I'm happy that with this event I get to check that off. What are alumni chapters? Alumni chapters are social organizations in cities where there are large and or engaged communities of Reed alumni. In Portland, there are over 3,000 alumni, Reed alumni, and what I and my fellow chapter committee members do is host events, whether that's monthly get-togethers at restaurants, book clubs, author events, garden tours, or bird watching. Our goal is building community and friendship, whether that's keeping the friendships that we developed at Reed alive or building new ones. Community and Reed's and the alumni's commitment to Reed and its current students is partially what brings us here tonight. Tonight's event is born out of the alumni community's desire to stay connected with the college and do what we can to help current students have the most intellectually and personally rewarding experience you can have while you're at Reed. Whether you want alumni to come to campus to put on events like tonight's or to talk about Ren Fair Paideia, all you have to do is get in touch with the alumni office. And I think I speak for a lot of Reed alumni when I say to current students that we are here for you. When writing this earlier today, I struggled to find words to describe how terrifying and alarming the current presidential administration is. There really are no words for it. It's completely upending the norms of this country and doesn't even try to hide how much it has in common with authoritarian regimes. We are less than 6 weeks in, and unfortunately, it is probably going to get worse. If you're scared, I want you to know that you're not alone. As a queer woman and a journalist, I am also scared. Many of my friends are, and it's something that we talk about quite often these days. And I think that feeling fear about what is happening right now is completely natural. But so is gathering in and recognizing the importance of community, being with like-minded people who understand us, support us, and help us during hard times. And I also think that it's important to share knowledge, which helps combat fear, discern fact from and reality from disinformation, and to know what we can do to protect ourselves and our friends. One thing I value the most about my Reed education is that it gave me a life of the mind. And no matter how many executive orders the current president signs, I think that they will never take away our ability to think, to learn from one another, and to use that knowledge to resist. And with that, I am very pleased to introduce tonight's presenter, Bear Wilner-Nugent from the class of 1995, who is a friend and also one of the first alumni that I met when I first graduated. Bear is a criminal defense lawyer with over 2 decades of experience at the trial, state appellate, and federal level. He is an aggressive and tenacious advocate for his clients and is also deeply involved in Oregon's legal community and has made numerous contributions to advance the development of the law. You may already recognize him from Ren Fair and other Reed events where he and the rest of the Meat Smoke crew have served smoked meat at various Reed events for decades. In 2014, he and the rest of the Meat Smoke crew were awarded the Babson Society Outstanding Volunteer Award, which recognizes outstanding volunteer efforts by Reed alumni. After getting that award, I know that a lot of Reed alumni sort of take a step back because their volunteer days have already reached their apex and the high water mark. But Bear continues to be deeply involved with Reed, and I am thrilled that he is here tonight to present The Law in Your Ass, which was one of the first Paideia classes I took in 2008, so I will be taking notes right along with you because I am in need of a refresher. And it is a presentation he promises will be a high-spirited but legally and factually correct look at your constitutional rights when it comes to the police and other law enforcement agencies and how to best protect them. Please join me in welcoming Bear Wilner-Nugent.
Thank you, Amanda. Thanks to the Portland chapter and to Reed for having me. It's nice to be back. Thanks to everyone for coming. I have been a criminal defense lawyer for over 20 years, and so I'm going to speak about what I want to talk about tonight. very practically. I'm not making normative statements. I'm not really advocating for what the future should look like. I'm talking about how to protect yourself and to understand your rights and advocate for them in the present. I'm also, as a lawyer, I have to be absolutely full of caveats. I'm a lawyer, but I'm not your attorney. The only way that I'm someone's attorney is either I'm appointed to represent them by the court or they sign a contract with me and pay a bunch of money. And so you can't become my client through going to my talk, even if it sounds like I'm giving legal advice. I'm not giving legal advice. I'm giving general information about your rights and answering your questions about understanding your rights. And that's as far as we're going to take it tonight. If you need legal advice, I'm certainly happy to connect you with the appropriate lawyer for your needs. I left my business card on the table outside. You're welcome to get them and pass them around. For the upper level people, if anyone gets up there, I guess there's nobody there now, but I stashed some there too, which are now spamming the upstairs. So, why this matters is because it sucks to be involved in the criminal legal system in general. It's not fun. I don't recommend it. Cops are real. Cops are real for all the normal reasons that they're always real, but especially the federal system is being bent against us in a particularly targeted way, targeted toward campuses like Reed, for example, just at the moment when we need to resist it the most. And so I'm adapting the talk that I have given before at Reed many times, either alone or with Andy McLean, class of 1992, and just for full credit also, not only did Andy help me develop these materials, but I stole the name from William Abernathy, class of 88, who originally titled his student handbook article about knowing your rights in the 80s, The Law in Your Ass. Anyway, I'm adapting this talk, which I've given at Paideia, given at Advance of Ren Fair, given various times around Reed for present circumstances. But most of it's the same. The heart of it is really not so much about what's happening in 2025, although we'll get to that, but it's about knowing your state and federal constitutional rights. And for any clandestine lawyers hiding out here, what we're talking about tonight is what we call in law school criminal procedure. And it has to do with constitutional law of criminal procedure, and that has to do with knowing your rights with regard to search and seizure, and arrest and detention, and answering police questions, and having contact with and representation by lawyers. So I'm not going to be talking a whole lot about the contours of free expression or free exercise of your faith or any of the other constitutional rights. I'm not going to be talking a lot about cruel and unusual punishment, other things that are involved in the criminal legal system. So we're going to cover, in order, more or less, under both state and federal constitutional law, we're going to cover search and seizure, like I said, arrests and stops, detention by law enforcement, statements to law enforcement, the right to counsel, how to invoke your rights, an orientation to the criminal process and what arrest and prosecution really look like. If we have time, we'll talk some about particular crimes and punishments. For people who haven't been to law school, we divide the world of the law up into criminal procedure, how the system works, and criminal law, what the law is, what's illegal and not, what crimes and defenses are, what punishments are. We're going to stick toward the criminal procedure side of things tonight mostly. And then I also want to talk a little bit about how to relate to a lawyer if you need a lawyer and how to be a good client. Then, after all that, assuming we have time left, we're going to get into some remarks on protesting, organizing, and activism with regard to criminal defense and criminal procedural issues in particular, and close with that topic. So, I'm happy to take questions anytime. I think the way that this talk was planned was that there would be questions at the end. It's not my preference. If the microphone system is not live, I can repeat questions, but it's going to be more natural and be more helpful, I think, and useful to you if questions can be asked anytime. So if they want you to go to a microphone, they're holding up microphones, there's going to be microphones and they can bring them to you. But raise your hand, and if you have a question, we'll get it recorded. But I do want to make sure that people are understanding concepts before we move on to the next concept, because I infamously talk very quickly, and in fact, I get in a lot of trouble for this in court, because there are still courts that use human court reporters, and even courts that don't use human transcribers to transcribe electronic records. So you can imagine the reprimands I've gotten from judges over the years. I'll just drink some water now. I'm so excited. So the first thing to understand about this talk is it applies to Oregon better than to the rest of the United States. We're always dealing, when we're dealing with criminal procedure, with an overlay of the state and federal constitutions. And some states have chosen, for political reasons over the years, to reduce the rights that their state constitutions protect to the federal floor. The federal 4th and 5th and 6th Amendments guarantee the basic rights that I'm going to be talking about tonight, and they're applicable to the states through the 14th Amendment's Due Process Clause. But those rights those rights exist in particular contours. For example, there's certain places you can search without a search warrant under federal law that you can't search without a search warrant under Oregon law. Because Oregon, or any state, can always provide constitutional protection for its citizens that's greater than that federal minimum. And in 1984, the US Supreme Court decided an extraordinarily important case in which it held that state constitutional law decisions, state Supreme Courts interpreting their own state constitutions, can never be reviewed by the US Supreme Court. State Supreme Courts in their federal system are the last word on state constitutional interpretation, which means Oregon, in state courts and state prosecutions, can give a higher level of constitutional protection, for example, against unreasonable search and seizure, than the federal system can give. So even federal courts in Oregon, they're enforcing your rights at that minimum federal floor. The state courts are enforcing a more robust, enhanced version of your rights. That's particularly true in the realm of search and seizure and in the realm of statements to police. It's less different in the case of your right to a lawyer. So a search is an intrusion by law enforcement into privacy. We talk about privacy in a technical legal sense, not to mean the same, I think, somewhat more narrow sense of personal bodily privacy or intimate privacy that we think about in our daily life. Legal privacy has to do with the concept of property rights, ultimately. And what is private property, more than some psychological sense of what's private to us, although that matters too. So searches are basically, you can define as law enforcement intrusions into privacy. And seizures are law enforcement intrusions into possession of property. However temporary, divestment of someone's possession of a piece of property. And so those are the technical definitions of what I'm talking about. And as you probably know, the Fourth Amendment to the US Constitution, which says you can't have unreasonable search and seizure, goes on to say that you cannot have a search warrant without probable cause to issue it. And so we need to define some of those fundamental terms as well. The Oregon Constitution protects those rights under a different number. We talk in Oregon about Article 1, Section 9 of the state constitution, but it says basically the same thing as the Fourth Amendment. So a search warrant is a command by a judge to law enforcement that says go to a specific place or a specific person or a specific vehicle, a specific phone, a specific computer, and search the contents of that place, whatever's on that person's body, whatever's in that building, whatever's in that vehicle, inside the digital device. And I say a command by a judge, but this is one of many legal fictions we deal with in everyday life in the legal system. The police officers ask the judge to command them to do this. A search warrant is supported by what's called a search warrant application or affidavit, and it's a request by a law enforcement officer to be ordered to search a place. It's being ordered in this sense is consonant with being given permission to search a place. And so a search warrant is the gold standard for police searches of places, but they're used in a very small minority of occasions of searches because search warrants obviously take time to prepare. It takes time to write a search warrant application. You have to say a lot about your knowledge as a police officer, your training, and a lot about the background of connecting general concepts of criminal procedural law to the specific investigation being undertaken and the specific place to be searched and the specific things to be searched for. And it typically has to be written by a detective or other more senior police officer, and it typically has to be approved by an assistant district attorney or deputy district attorney or assistant United States attorney, or all the different names we call working everyday prosecutors. Not every search warrant application is approved by a prosecutor, but the point is it's a process. It also involves going before a judge, either in person or by electronic communications, and being sworn to tell the truth and testifying in a one-sided manner to the judge about the facts supporting the search warrant application and answering the judge's questions. So police like to get around the search warrant requirement because although a search warrant is very hard to challenge, you can challenge them, but they're hard to challenge, it's also very hard to get, they think. They make it, cops like to pose that it's very hard to get a search warrant. And so we talk mostly in criminal law, we talk about searches and seizures, about exceptions to the warrant requirement. And that's what I'm going to spend a lot of time talking about tonight in the next part of this presentation, about warrant exceptions, because they're the ways that people are most likely to find that their rights are being violated by the police with regard to property as opposed to with regard to statements or memories. The number one exception to a search warrant requirement is that somehow the circumstances are what's called exigent, that evidence is going to vanish or be destroyed or hidden because of the passing of time. There are many instances in which different kinds of exigencies, different kinds of emergencies have been used to justify searches. And when I say justify, I'm going to talk a little bit later about how searches are challenged in court. So just assume that there's a process, and we'll get to what the process looks like in a few minutes. But the concept that evidence is going to vanish or that circumstances are going to change irrevocably with the passage of time have legitimated many searches that otherwise wouldn't be allowed. There's also exigencies having to do with danger to persons. For example, police hear what sounds like a fight or a beating behind closed doors. They break down the door, focused on personal safety of the person being beaten up or fought with, and then they discover contraband, drugs, whatever it might be. And exigencies that relate to personal safety can legitimize searches that otherwise would require a warrant. However, there's one common touchstone to warranted and warrantless searches both. Whether you have a search warrant or a search warrant exception, you still have to have probable cause. So just police perceiving that there's some kind of emergency going on is not enough. Probable cause means it's more likely than not that a crime is being committed. Probable cause to search means it's more likely than not that a crime is being committed and evidence of that crime or the proceeds of that crime, something related to that crime, is going to be found in the location to be searched. Probable cause to arrest a person, which we'll get to a little bit more in a few minutes, has to do with the concept that a crime is being committed more likely than not, and that the person being arrested more likely than not committed the crime. And I say more likely than not advisedly, because that's very different from the standard for proof of a crime in court, which we all know is proof beyond a reasonable doubt. The probable cause standard is vastly simpler and lower than that. But both warranted searches and warrantless searches have to still meet the same requirements for probable cause. So when you think of a warrant exception like exigency, like the passing of time and the vanishing of evidence, the drugs are going to be flushed down the toilet, you have to think that there has to be accompanying probable cause and then something that gets you outside the warrant requirement. And that's true for every warrant exception except for consent, which we'll get to in just a second. Another very important warrant exception for people to know is search incident to arrest. If you are arrested for protesting and you have drugs on you, that is bad for you because you don't have to have a search warrant to search the person of a person who is being arrested, the body, the clothing, the immediate possessions. In Oregon, we have a fun wrinkle about that, which says you can't search a closed, opaque container on the property, on the person of someone being arrested just because they're being arrested. And there's a wrinkle to the wrinkle, which says, unless the container announces its contents. Which does not have to be an audible announcement, just for the record. Yeah. Thank God someone's asking a question. Go.
So if the container is like labeled, but it's mislabeled, how does that play into it? Like, say I have a bottle that says, like, I don't know, whiskey on it, and I put something else in there, like weed. Like, how does that?
It depends on circumstances that are probably too individualized to give you a great answer. We can develop that hypothetical a little bit later. But the answer is, the courts would say the touchstone is reasonableness and other platitudes like that. Generally speaking, if they seize a whiskey bottle off the person of an arrestee, they're going to inventory it as one whiskey bottle unless it's obviously transparent showing something else inside. Okay, speaking of inventory, I'll actually riff on that. Another kind of search that can be done without a search warrant is what's called an administrative search, which is a search that's done by government officers, but nominally for some government purpose that's legitimate and unrelated to criminal investigation. However, there's some quote-unquote administrative searches that we call inventories in Oregon that are so close to the line of criminal law enforcement as to make the line vanish altogether. And those are inventories of vehicles. And generally speaking, if a person is arrested and they've been arrested from their vehicle, in many circumstances the vehicle can be towed, either because there's a law saying you always have to tow the vehicle of a person arrested for a certain crime, driving under the influence, driving while suspended come to mind in a lot of jurisdictions, or because it's parked in a hazardous way or a way the police say is hazardous, left in a place it can't be parked. And so before towing a vehicle, there can be a policy, a police department can have a neutral policy, and I say neutral because I mean without regard to particular human circumstances, a policy of searching in a prescribed, written down manner all the compartments of a vehicle? Yeah.
I just have a question about like the towing part. Apologies if I'm taking you off course.
That's fine.
Would the state pay for the tow costs, or would they like?
Oh no, the person whose car it is pays for the tow. That's a good question. Yeah, don't get arrested. Yeah.
When you say administrative search, is the search conducted by law enforcement agencies or other state and federal agencies?
It can be, and I'm getting to that. I'm saying there's searches that are done because they're looking for criminal evidence, and there's searches that are done either really for other purposes or ostensibly for other purposes that then can discover criminal evidence. Because another exception to the search warrant requirement is what's called plain view. And the point, these exceptions work together. If the police have the right to enter a house because they think domestic violence is ongoing in there and they discover drugs that are in plain view inside the house, they aren't hidden away somewhere private, they can seize those drugs if they have probable cause, that is the belief they really are illegal drugs. Just because they were inside the house under one warrant exception, they're then using another warrant exception. These exceptions can concatenate together. But it's just so with administrative searches like inventories. Somebody's car is getting towed. Well, why is it getting towed? It's getting towed because it was parked illegally, without any reference to that police were the ones who caused it to be parked there because they stopped the car there. But it's being towed for an ostensible, that's why I say ostensible, non-law enforcement purpose. It's a traffic enforcement purpose. And so the search of the car, as long as it's done according to what I said earlier, a neutral policy, if it turns up evidence in plain view, no search warrants required. And that's what I'm really getting at. And I say administrative searches are a more general category than inventories because an administrative search can also involve like a search of a regulated business. Let's say someone owns a weed store. They have to let OLCC agents go in and search their weed store for certain things. If they have other drugs there they're not supposed to have, that's bad for them, that kind of thing. So we've talked about exigencies, search incident to arrest, inventory and administrative searches, and the overarching concept of plain view. There's other warrant exceptions, although they're more minor, especially in Oregon. But the one that I want to talk about that really matters is consent, because consent is the search warrant exception that does not require probable cause. And it is the one that people are most likely to have encounters with in their daily lives if they have unfortunate encounters with law enforcement. Police can ask you to give up any constitutional right, and in the moment, without a lawyer's advice, without being psychologically pressured, you can give up the right to be free from unreasonable search and seizure very quickly and easily. And there's no Miranda warnings for searches. There's not a prescribed warning with regard to counsel that you have to be read simply because your property is going to be searched by law enforcement or your person is going to be searched by law enforcement. And police have honed to a fine art the ability to coerce consent to search. If you give up your own rights, I can do very little in the future to protect them. We can argue about the circumstances under which consent was gained, but you're starting from a losing position in that argument. It's better not to have given the consent in the first place. So, by the way, with regard to both search and seizure and stops and arrests and statements to police, with regard to all these criminal constitutional concepts, after I go through kind of the basic outlines of what the Constitution protects, what rights you have, then I'm going to talk about how to invoke your rights. So we are going to get to that, and I'm going to have a more punchy and more focused, brief section just on invoking your rights. But I'm trying to give the background that explains why the rights matter first. So I appreciate you bearing with my process. Another way to think about searches, in addition to search warrants and exceptions to the search warrant requirement, is to think about searches in terms of a nested series of zones of privacy, where you have more privacy and more constitutional protection, where you have less privacy and less constitutional protection. And so we start with the human body. The place that you're most secure against intrusion is your own body, still to this day. And typically speaking, you don't get to search people's bodies or their clothing except for either a search warrant, consent, or a search incident to arrest. There's not a lot of general circumstances under which police, without a warrant, encounter a person and they can force the person to surrender the contents of their pockets without arresting them. I'm saying that in a not very grammatical way, but I think you understand the concept. Moreover, to intrude into the body, to require a sample of bodily fluids, for example, pretty much always requires a warrant, with the exception of drunk driving, blood and urine and breath testing. And blood testing typically in Oregon always requires a warrant. But they're very, very easy to get telephonic and other electronic warrants for blood testing for DUII. We'll get to DUII in a little bit because I want to talk about that if we have time to talk about particular crimes. Outside your body, your personal belongings that are immediately on your person have the next best protection. But remember the plain view rule. So transparent containers, translucent containers, open containers have less protection than closed opaque containers. Homes have, yes? Yeah.
I'm thinking of purses. Purses, you cannot see through a purse, so it's an opaque container. It also might be considered clothing, or it might be considered a container. And I could imagine a circumstance where you have to take your ID out of your purse because they ask to see your ID, and at which point it becomes open, and then is it no longer opaque?
Yep, that's right. So that's why not to have contraband with you if you can avoid it. To put not too fine a point on it. Yeah, Amanda.
What about smartphones?
We're going to get to digital device searches in a minute. So I would say that on the spectrum, I didn't really design this talk in the digital device search era. I've been giving it for even that long. But I would say that on the spectrum of protection, nowadays, phones are next in many ways before we get to any less protected area. But I want to talk about how phones can lawfully be searched in a few moments. But after your person and your belongings, including your phone and your closed opaque containers, the next best protection under the Constitution is a home. Typically your own home, but any home in which you have privacy rights. By the way, if you ever read about these concepts outside this talk, you'll hear federal sources and typical American legal sources talking about a reasonable expectation of privacy. And remember I said a few moments earlier that Oregon protects a higher threshold of rights than the lower federal floor of rights. Oregon also has an extremely high-flown and precious legal vocabulary all its own, and Oregon courts love to be persnickety about word usage. And a lot of this traces back to a Reedy, unsurprisingly, named Hans Lindy, who was an immigrant from in the World War II generation and went on to become a very great justice of the Oregon Supreme Court in the 70s and 80s. And he created the concept of independent Oregon constitutional interpretation really as an important legal concept. And he also had a lot of extremely strong preferences about language. And judges who were influenced by him also have these preferences. And that's why I'm conditioned to say inventory and never say the word inventory search. Don't ask me why, it's a rabbit hole. But in any event, Hans Lindy also said, it's not the privacy that you have a reasonable expectation of that the Constitution protects. The Constitution doesn't protect what you expect. The Constitution protects what you have a right to, which sounds tautological, but it's meant to be a statement of how robust your rights are, that it doesn't matter what's subjectively in your mind about what you think your rights are, that the Constitution guarantees everyone a certain set of rights. And that's what he means by not the privacy you expect, but the privacy to which you have a right. You're entitled to that privacy whether you know it or not, if that makes sense. Very important thing by Justice Lindy. So the next best protected place around after a home is what's called the curtilage. If you learn law, you're cursed in this system of English common law to learn a bunch of Norman French. And curtilage is one of these weird French words that persist in legal English that no one knows what it means. But it basically means the area close enough to your house that you have a right to privacy in that area. If you have a back deck with a hot tub, that's in the curtilage. If you have a field where you grow a crop, that is not in the curtilage. That's the easiest way I can define it. There's a lot of individual variations of the different houses. Yeah.
So you just said the back deck falls under that weird French word, but pastures don't. My question was, what about just the physical land property that you own, like the boundaries of it?
Generally speaking, it's easier to intrude into land than it is into the curtilage, but if it's privately owned land, it's harder to intrude than any public place. And that's what I'm talking about, a cascade of increasingly dilute zones of privacy. And this matters in a number of different search warrant and search warrant exception analyses. And I'm trying to convey general concepts here and not say how each exception plays out in each circumstance, because that's how we have a whole semester course on criminal procedure. Actually, you have to take 2 criminal procedure courses to graduate from criminal law school. So yeah, a whole year, I guess. All right, anyway. So yeah, open fields are next. Other buildings, Buildings that are, barns, outbuildings, have about as much protection as open fields. Generally speaking, working spaces have less protection than living spaces. Private conveyances have more protection than public conveyances. Oregon abolished a rule that we have in the federal system. Under the federal system, there's another exception to the search warrant requirement called the mobile vehicle exception that says basically if you encounter a vehicle in connection with a crime and the vehicle's mobile at the time that it's encountered, then it can be searched. Simply because that's an exigency. The idea that someone else could come and drive the vehicle away before the search warrant is written is an exception to the Constitution, an exception to the search warrant requirement. Oregon completely abolished that in 2023. There was a massive decision by the Oregon Supreme Court. Another Reedy, Justice Brunson James, who's currently on the Supreme Court, actually we have two Reedies in the Supreme Court, but Justice James was more involved in this particular decision, helped abolish the motor vehicle exception in Oregon. And so in Oregon, you cannot search a private car just because the police pulled it over. And that is you can't go in the trunk of the car, for example, without plain view, without some or consent. That's why the police try very hard to develop consent in automobile stop situations. I'm already going over on this section of the talk, so I'm going to move along. But suffice it to say, there are places further down the spectrum where you have an extraordinarily reduced set of rights by your own voluntary choice to participate in air travel or crossing international borders. You do not have a right to privacy in those particular circumstances that is really enforceable by the courts. You have a choice to avoid putting yourself in reduced constitutional right territory. We don't have the regular border situations in Oregon, obviously, and I'm not going to talk about seaports, but so if you go to fly and you put yourself in the TSA's hands, they're performing an administrative search that you consented to have performed upon you. So you do not have the same right to privacy in property you put in the TSA's custody, however temporarily. Digital device searches, I said I was going to talk about that. Another set of important decisions from both the US and Oregon Supreme Courts in the last decade have said that there is no plain view in a phone. There is no plain view in a computer. There's no general rummaging around without a particularized warrant to get into the contents of a digital device. You can't search someone's cell phone because they were arrested. You have to have their consent or you have to have a warrant. You have to have a warrant in Oregon. You have to have a warrant to seize a phone for any particular length of time. You can't keep a phone without consent or a warrant in Oregon. You can't keep a phone hoping that later on you'll then develop probable cause to search it. The probable cause has to be fresh. The law actually has a concept called staleness, and the idea that facts that the police knew at one past time may have changed with the passage of time. So digital devices are, as I said, they're up there in the hierarchy now, higher than they used to be. And that points to another underlying principle, which is that these constitutional rights sound, time-honored, and the words we've used to enshrine them are very old, but in fact, the contours of them are always flickering at the periphery. And the appellate court decisions are very numerous. You have to keep up on them to understand how the rights are being enforced in practice by the court. One more thing I want to say about invasion of privacy before we move on to talking with the police, and that is wiretaps. The number one misconception I think about criminal procedure that I experience with populations like you guys is the idea that the police are listening to your phone calls. And certainly there is bulk data collection for spying purposes by the federal government. We knew that under the Bush administration. And certainly the technology has only gotten more robust, right? I'm not talking about international spying. I'm talking about domestic law enforcement, things you can get prosecuted for, criminal law. Wiretaps are still very hard to get. The state system in Oregon basically does not use wiretaps at all. The federal system in Oregon uses wiretaps extensively, but the personnel needs to staff wiretaps are so great that they only use them for very serious federal investigations. And concerted investigations over periods of time, typically of drug trafficking conspiracies, occasionally other kinds of cases, but 95% of the wiretaps in Oregon are federally prosecuted drug trafficking conspiracies. And they have to be gathered, they have to be authorized through a process that involves federal cops, federal prosecutors here in Oregon, federal administrative officials at the DOJ in Washington, D.C., and a judge in Oregon. And they have to be renewed on a periodic schedule. And extensive record keeping has to happen, and just the data needs are very bandwidth hoggy. And so you're probably not being listened to in your phone calls. And that is the most reassuring thing I sometimes can say in this talk. Many people have a misimpression that it will, that they're going to give away their life on the phone. However, I will say one thing too, that if for some reason you are involved in a part of life that's being wiretapped, there is no kind of code you can ever use on a phone call to save you. Absolutely every code that I've ever seen being discussed on a phone call in a wiretap case was transparently figured out by the feds working on it. I've never seen any exception to this principle in my 20 plus years of practice. Did somebody have a question? Yeah.
Can they wiretap Signal?
So far, no. However, Signal is great for encrypted end-to-end digital messaging. It's what I recommend. But you still shouldn't write down anything about committing crimes, or you're going to commit a crime, or you did commit a crime, because Signal is permeable just as much as anything else with consent. And it's not the technical aspects of Signal that make it dangerous, it's the human aspects. Technically, it's very robust as far as we understand. Yeah, back in the back.
I have a related question. So you said there's a heightened standard for like cell phones to get into them.
Yeah.
What about digital data held by third parties, like my Facebook messages and communications?
You do not have a privacy right typically in digital data held by third parties. Your rights are subject to the terms of use, the contract that you have, what we call in the law a contract of adhesion, a one-sided contract imposed on you by a powerful company, and that does not protect your rights. That's for their benefit, not yours. Yeah. Yes.
I've heard, previously I've heard that like when people go to protest, they should like disable their like Face ID. And I'm wondering if like, that, I don't know how, trying to figure out how to say this. It relates to like how Oregon views like possibly police like using your Face ID to get into your phone if you're like incapacitated or whatever.
In Oregon, you can't use the Face ID to get into somebody's phone simply because the phone was seized incident to their arrest or detention. You can get into Face ID, you can use Face ID to get into a phone with someone's consent. The more dangerous situation is when police have a warrant for a phone, and the warrant contains a command by a judge that the person's either display their face or press their finger to the phone. It is not typical in a protest situation which you're talking about for there to be a lot of phone searches going on unless there's people who are a particular focus of attention because of something they were doing with their phone. But generally, I want to get to this at the end. I'll come back to this a second time because I do have some thoughts about conventional wisdom about what is good and not, what isn't is not good practice of protests. Yeah.
Just to be clear, when you talk about Oregon protections, does that apply to federal law enforcement? Like if I get arrested by marshals right now?
No. So that is a very good question. Inside Oregon, we have two parallel court systems, and that's where the protections really apply because that's where they're enforced by judges in court. And so we have the state court system, which applies the Oregon Constitution and the federal Constitution both, and defaults to whichever protects more rights. And we have the federal system, which only here and in every state only applies the federal Constitution, which has, in some instances, vehicle searches and digital device searches, but especially vehicle searches, has different rights. And it also, there's different case law about coerced consent. There's a number of issues that are different. So I hope that answers your question. Up in the back.
So I guess I'm trying to distinguish in what cases would the different legal systems be applied to you? Does it like depend on who you get arrested by?
Who you're prosecuted by. Yeah, so that's a good question too, because officers belong to a particular level of government. They're trained by, they're paid by, they're regulated by a particular level of government. But they, in practice, in modern life, in Portland certainly, they work together. We just have many more state and local officers than federal ones. Federal officers can be involved in state cases, but what's much more frequently is the case is that state officers are involved in federal cases. Because one of the other things I'm going to come back to at the end of this talk when I talk about protests and organizing is that there's one of the big dirty secrets is there's just not very many feds. The whole country has 13,000 FBI agents. There's 350 million Americans. And it goes on. FBI is the largest general purpose federal law enforcement agency with 13,000 officers, much, much smaller than the New York Police Department, for example. And there's just not very many feds. Federal cases depend on state and local officers. Sometimes they're formally cross-deputized and they're sworn in as special deputy U.S. Marshals or special FBI agents, but more typically They are just considered task force officers. They all work together. Does that answer your question? All right. We're going to move on from search and seizure, but I want to talk about one last search and seizure topic, which is how this plays out in practice. The police are going to do what they're going to do. It's when the pieces are being picked up that we get into litigating all these issues in court that I've just been talking about for the last half hour. It's best to deny consent to a search. We'll talk about that again. But it's also best to stand back and not interfere with police action, because the time to fight about it is when you have a lawyer and you're in court. You can challenge the use of evidence in court. A lawyer can challenge the use of evidence against somebody in court because of a violation of their rights against unreasonable search and seizure. And the typical vehicle, though not the only one, the typical way this is done is what's called through a motion to suppress evidence, which is a request to a judge that the judge issue an order that the evidence can't be used in the prosecution of the person. And that's where all these issues get fought about in court. And when they're fought about in the trial court and someone loses and is aggrieved, they can appeal to the Court of Appeals or the Supreme Court. And that's where the principles are laid down that are supposed to be persistent and durable and last from case to case and be applied in comparable situations. So that's how this law develops. It's through a period of time with people losing their cases, going to prison or being put on probation, and then appealing and winning the appeal. That's a big part of what I do, is I do court-appointed appeals for the state. So I represent people who cannot afford lawyers, who've already lost their case in state court, and the Court of Appeals and the Supreme Court of Oregon pay me to try to get them a new trial or a new proceeding below. Okay, so let's talk actually about seizure of persons before we get on to statements. There's a continuum of police interference with your body, with yourself. With regard to property, it's kind of more black and white. Either the cops are handling the property, you're handling the property. With regard to a person, there's an ambiguous state in between being arrested and being free. And that's called being detained or being stopped. And what's important to know is an arrest requires probable cause. It requires proof, ultimately in court if necessary, that a crime more likely than not happened and that the person who's going to be arrested more likely than not committed the crime. And if an arrest is done without probable cause, then the evidence that's gathered as a result of that arrest can't be used in court. And Oregon courts are very good about that. And we win cases on appeal all the time where someone was wrongfully arrested. That does not get them compensation for being wrongfully arrested, but it can end a criminal prosecution. With regard to a stop, though, or an investigative detention, the standard is lower. It's what's called reasonable suspicion. And that is something better than a hunch, better than a whim or an incident of prejudice or bias, but not much better than that. It's got to be something that somebody can articulate in words, a justification that can be retrospectively given after the leisure of months perhaps to think about what the justification was for why an officer stopped the person. So saying that someone was falsely arrested provides much better protection in court than saying someone was falsely stopped or detained. And that brief ambiguous state of being stopped is the source of a lot of, is the camel's nose under the tent of a lot of subsequent police investigation. So it's important to not persist in a state of being stopped. If someone's detained for a period of more than a few minutes, lawyers want to begin to argue that the person has been arrested, even if the magic words aren't said, even if a cop never says you're under arrest, even if handcuffs aren't applied, even if someone's not transported to a police station. Those things in Oregon, any one of those things really makes it an arrest. Any one or any combination of those three things, handcuffs, being told you're under arrest, or being transported, moved from any place to another place is an arrest in Oregon. Being moved to a scene of a crime, to be identified, what's called a show-up, to be paraded in front of a witness, that's an arrest. You can't be temporarily detained and moved to another place and shown off to somebody. That's automatically an arrest in Oregon. Federal law is different. Other states' laws are different. But you want to not be stopped for very long. And so it's wise, from my perspective, if you're being detained, it's wise to ask if you're free to go. And if you're not free to go, then you're going to do the thing that I'm going to tell you in a few minutes about how to invoke your rights. Stops only apply in Oregon to a person. A traffic stop of a driver. Traffic stops are necessarily of drivers, right? Unless they have reliable intelligence that someone's traveling in a particular car, which is a pretty rare circumstance. Traffic stops in Oregon never stop the passengers. If you are the passenger in a stopped vehicle, and it is safe to do so physically, you can get out and leave. They cannot lawfully detain you. They cannot force you to provide your ID. That is a rule that is exceptionally different from other jurisdictions. Do not rely on that principle outside of Oregon. That is an Oregon state constitutional principle that passengers are always free to go. That was very hard fought and won in the last 15 years. Before 15 years ago, it was different law. Traffic stops apply to bicycles as well. People can be stopped or temporarily detained in a vehicle under more circumstances than they can when they're not in a vehicle. Because, as I said, you can only be arrested on probable cause, but your vehicle can be stopped. Yeah, you have a question here.
Yeah, I was just going to ask, like you were saying about the passenger who can just leave.
Yeah.
If, for example, both people have been drinking or smoking or whatever,
Yeah.
the passenger can still just leave.
Right. It's not a crime to be under the influence if you're not driving. It's not Oregon law specifically forbids there being a crime of being under the influence of drugs. Was there another question there that I missed?
No, I was actually just going to ask, and that's different from all other states or most other states?
I can't opine about the law of all other states. I know a lot about federal law and a lot about Oregon law. I know a little bit about the law of a couple other states by accident, but I'm only licensed in Oregon.
Fair enough.
Yeah.
What about the self-driving vehicles? Will law eventually catch up to that?
Yes. As I was saying, search and seizure law is dynamic, and as we've given some examples of that already. Oregon abolished the mobile vehicle exception 2.5 years ago, and it abolished, the passenger detention 15, 18 years ago in my career. So yes, there will be changes of law, but you also picked the wrong person to ask this because I'm a profound self-driving car skeptic. Yeah.
So if the passenger's free to go, are they free to go in the car? Like, can they just get in the driver's seat and go? Or
Typically not. If you're interacting with law enforcement and they're stopping a driver and they're wanting to investigate the driver, probably it's inadvisable to try to take the car and drive it away. Okay. So you can be stopped in a vehicle, as I was going to say, based on probable cause for a traffic violation. And that is a lesser standard than probable cause for a crime. Because ultimately, proof of a crime involves the concurrence of two things: a physical act of some sort and a mental state of some sort on the part of the person who committed the act. For example, knowingly stealing something. You could accidentally take something that's not yours and it's not a crime. But if you do it and you know it's not yours, you know you're not supposed to take it, it's a crime. The mental state makes all the difference. There's no mental state for traffic violations. And that's true for a certain small subset of crimes that we call strict liability crimes, and the main one of those is driving under the influence. There's no mental state. They don't have to prove that you knew you were under the influence, that you thought you were under the influence. They just have to prove physical things. And so it's much, much easier to stop a person for a traffic violation and subject them, perhaps, to all the other kinds of police investigative tools and invasions of privacy if there's a traffic violation. And that's why it's important to be especially careful if you're controlling a vehicle, because you are reducing your personal rights with regard to law enforcement just by controlling the vehicle for as long as you're doing it. There's a third level of police interaction with citizens in addition to arrests and stops, which police tend to call mere conversation. And it's always a somewhat ominous mere, because how often do you have mere conversations with law enforcement officers? Unless you happen to have one as a personal or family friend. You're not going to have a lot of those. But a lot of times, police try to begin an investigation through an exchange that's nominally not coercive, nominally consensual. A person can stop it and walk away at any time. The problem is they are conditioned to not realize they can walk away, and that you shouldn't have to ask for permission to walk away. You can just remain silent, literally. You can turn and walk away. If you're told to stop, if you're told to come here, if you're told to stay there or sit there, you're being detained. Any command that controls your movement in Oregon is detention. So it can't be mere conversation. All right, any questions about that before we move on to statements? Yeah.
When can I be required to identify myself?
That depends state to state. In Oregon, generally speaking, you can't be stopped for identification. In Nevada, you can be stopped for identification. I know because there's a famous U.S. Supreme Court case saying it was cool for Nevada to do that. Oregon Constitution says no, though.
So if I'm detained, I don't have to give my name or provide my identification?
Correct. If you're arrested, you have to do it eventually, or you won't get processed for release. And we'll talk about the process of criminal prosecution, arrest and prosecution in a few minutes. But if you're arrested, you should give your name to the people who are detaining you for practical reasons. But if you're not arrested, there's no need in Oregon. If you're being investigated and the officer commands you to provide your ID, however, you should provide it. If it's a traffic investigation, I'm sorry, I should also say traffic laws require you to provide your driver's license on request to an officer enforcing the traffic laws. So if you're stopped driving a vehicle or a bicycle, which is a vehicle, you can be forced to provide your ID even if you're not arrested. But outside that situation, you can't. At protests, you can't. In altercations between two people that are not a vehicle situation, you can't be forced to identify yourself, generally speaking. However, you can be given a request that sounds like it has force. But the cop can't override your no. They can't go into your pocket and take your wallet out and look at your ID without your consent. If it's an arrest, your wallet's going to be taken incident to the arrest and probably inventoried pursuant to a jail inventory policy, and your ID is going to come out anyway. Hopefully I'm not being too unclear. All right, so let's talk about statements. Everyone knows what the Miranda rights are, and here we're shifting finally from the Fourth Amendment, or Article 1, Section 9 of the Oregon Constitution, to the Fifth and Sixth Amendments, in Article 1, Sections 11 and 12 of the Oregon Constitution. And everyone knows about the Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to represent you at no cost. And a lot of officers will follow that up by saying, do you understand and waive these rights? Imagine the language barrier for people who speak English poorly, don't know what a waiver is, and think, hey, maybe waiving something means showing it off. They're like, I'm waiving my rights. Seriously. But there's a lot of circumstances under which police have had very valuable evidence, had very serious prosecutions, up to and including murder prosecutions, completely dismantled because they didn't correctly Mirandize someone. In Oregon, you can't use someone's statements against them unless they've been read their rights under two circumstances. One is what's called custodial interrogation, statements after an arrest. If someone's been arrested, and that means they've been handcuffed, they've been told they're under arrest, or they've been moved by police from one place to another, any one of those three things or any combination of them, if they're questioned after that, they have to be read their Miranda rights first. But Oregon, because we do have a more expansive set of personal criminal procedural rights, also protects you and your statements to police under what's called compelling circumstances. And those are circumstances in which the police presence is so intrusive and overbearing that even though someone's technically free to go, they still should be Mirandized. They still should be read their rights before their statements can be used against them because of the gravity of the police intrusion on their psychological situation. And so what I mean by compelling circumstances is creating a police-dominated atmosphere. I won a case, the most recent case that I won in the Oregon Court of Appeals, I won a few weeks ago, and this is a case where the police came to someone's home and they talked to her about her husband's crimes for 45 minutes, sitting around her table about the things they were investigating her husband for. And then they started pivoting to talking about the things they were investigating her for. And they stayed with her in her kitchen for an hour and a half more. And all those statements got her into a lot of trouble. And I just won her appeal saying they couldn't have used any of those statements because that was compelling circumstances. Because even though it was her home, comfortable, familiar place, and that she had the ostensible right to eject them from her home any time, the duration and the overbearing police presence in her home resulted in the suppression of her statements because their circumstances were compelling simply because they were police-dominated. Even though she was never moved from one place to another, she was never told she was under arrest, and she was never handcuffed. Does that make sense? But it's a narrow exception. You don't have to rely on that. She wasn't Mirandized because they didn't arrest her. They didn't think they had to Mirandize her. But they bet wrong because it was compelling circumstances. And we found that out years after the fact. She served 5 years in prison so far? In jail and prison, so pretty bad. Statements that are not given in custodial interrogation, not given under compelling circumstances, there's no Miranda rights there. There's no requirement that a warning be issued there. Generally speaking, statements that are consensually given, that are given after adequate warning, more to the point, can be used against a person and frequently are. They really mean that when they say they can be used against you in a court of law. Most criminal cases go badly for defendants because they talk. It is really that simple. There is no circumstance in which you're having an unfriendly encounter with law enforcement in which talking more will help you more. It is always a one-way ratchet. And we will get into more of that as time allows. There's one more right that's obviously very important that's bound up in those Miranda rights is not just the right to remain silent. It's the right to an attorney. The right to an attorney is different from the other rights I've been talking about. The rights having to do with search and seizure, arrest and being stopped, and your statements, those are general personal rights that apply across every circumstance sort of continuously. But the right to a lawyer only applies if you're being prosecuted. You can ask for a lawyer during police interrogation. You will not, unless you have a lawyer of your own already hired that's ready to come down and talk to you, you won't actually get a lawyer. But what you'll get is a pause of interrogation. If you ask for a lawyer, that does not mean that you are freeing yourself from further police contact. Until a lawyer is actually representing you, there are circumstances in which the police can use your own doubts and weaknesses to get back in touch with you. So they're supposed to stop asking you questions if you ask for a lawyer, but if you then reinitiate contact with them, and they take a very broad definition of what reinitiating contact is, that can undercut your request for a lawyer. So you have to not only ask to speak to a lawyer, but you have to actually remain silent until the lawyer arrives. If you have been arrested, that will not help you get out of jail. You will have to wait until you go to court and see if a court case is being brought against you before you actually get to talk to the lawyer. There's no phone line at the police station that calls a public defender down to talk to you. That is very, very important to understand. To exercise your right to an attorney means insulating yourself from police contact for as long as it takes to get the attorney. And in a detention situation, that can mean a longer detention and all the collateral consequences, all the dominoes that fall that are downhill of being detained for that period of time of your life. And that's what makes the right to counsel different, is that, the right to say no to a search is sort of self-affecting. But you have to have someone else's participation, the lawyer, with the right to counsel. So the best way to invoke your rights is to, first of all, decline to consent to a search. And if, as the Grateful Dead said, if they have a warrant, I guess they're going to come in. But otherwise, you're saying no, and maintaining that no under pressure is the most powerful thing you can do. If you're arrested, you submit to the arrest peacefully, don't resist arrest. But if you're not arrested and you're being detained by police, ask if you can leave. If you can't leave, ask if you're under arrest. However, don't feel the need to be cheeky and say that stuff a lot if it causes you problems with the cops. There's no particular points you get from saying that. A lot of Know Your Rights training has really emphasized badgering cops about that. I don't go with that. I think it's better to understand your circumstances, because you're going to want to tell, if you have to have a lawyer down the road, tell your lawyer what they said in response to that question. That's useful information, but you don't have to go through an endless cycle of am I under arrest asking every minute. If you're being detained for an excessive period of time, eventually it can become an arrest just through that too. Depends a little bit on the circumstances. For example, you can be,
So one of the things you said is if you are commanded to stop and talk to the police, that you actually have to do that.
Well, you don't have to talk to them. You have to stop. If a police officer commands you to stop, I advise stopping.
Right.
I don't advise running from a cop.
Right. That can be dangerous. But like if let's say you're downtown and there's some kind of commotion, and they say, "Ma'am, would you come over here a minute? Did you see what happened? Yada yada." I mean, how much of that do you cooperate with if it seems innocuous before suddenly you're getting yourself into a situation?
I can't speak for the particulars of a situation, but I would say generically, if you don't want to be involved, don't choose to be. And if they repeat commands, attempt to apply force, attempt to obstruct your path, you may have to make a different choice. But I mean, generally speaking, you're free to ignore inquiries. If you're being given commands by someone in uniform who's exercising the power of their office that they took a supposedly important oath to conduct in a particular way, then you should probably find out what they want, is my practical advice.
Thank you.
All right. So generally speaking, you want to say no to searches. You want to try to leave police encounters that you don't wish to be having anymore. If you're under arrest, you don't try to leave. You should ask to speak to a lawyer. If you want to not talk to the cops, you should say, I want to talk to a lawyer, and then remain silent. This is the result of some U.S. Supreme Court cases that in the interest of time I'm not going to discuss the details of. But suffice it to say that the upshot of recent U.S. Supreme Court decisions from the last 10 to 15 years is that it's good to say you want a lawyer and then say nothing. It keeps you from being badgered by the cops better than if you simply say nothing. It's also okay to answer arrest and booking questions if they ask you questions that are designed to find out if you're chronically ill or if you're a suicide risk in jail or who your next of kin is. It's fine to answer those questions. There can be practical detriments to you from not answering those questions. The booking questions that are conducted by people who are operating a detention facility are very different from questions that are investigative, that are being done by officers investigating a crime. I advise you to have legal help when you're being investigated for a crime. And if you have to wait for that legal help, I advise you to wait for that legal help. So, in other words, don't quit when you're ahead. If you said no to a search, if you said no to talking to the police, you're ahead. And don't retrench in that and just step on your own benefit. So now I've caught up, so that's good. I can go a little slower. The criminal process, and we have more of a spectrum here than I thought we'd have. I thought we'd be more student heavy, so I think a lot of alumni may find this pretty familiar. But I'm still going to go through the same thing I would go through anyway, because I want to make sure I'm giving consistent information year over year when I give these kinds of talks at Reed. The most important thing to know is that the criminal process is very slow and cumbersome and sucks away a lot more of your time than you think it will. Even a simple arrest for driving under the influence is a very disruptive experience that will have ripple effects that will change someone's whole month, not just the night or two they might spend in jail. And from there, the toll goes up. Most of the time, people being arrested in present day in Portland, we're back to having enough jail capacity to detain people for a lot of crimes. There are some crimes that they never basically detain people for, that they will always cite people and release them unless they have another reason to hold them for a different case. Things like shoplifting. But generally speaking, people who are arrested are not going to be released without going to some kind of a jail facility and being processed through it. There's another subset of people that are processed out in the initial jail encounter, because Oregon recognizes 3 levels of suitability for detention for arrested people. This is a kind of a modern change to the Oregon system. And so I'll try to explain it just in very non-technical terms. Because this matters to not only the people who are being arrested, obviously, but it matters to the much greater number of people who might know someone who's being arrested, might want to support or help a person who's being arrested. And I always try to tell people, and my advice is not for you, you're perfect, it's for your terrible friends. But the 3 levels are release on recognizance, conditional release, and security release, which is a fancy term for bail. So many states have systems that are very heavily reliant on cash bail, and they have private bail is when you give some money to the court to hold as a guarantee that you'll come back, because presumably you want to get your money back, and they won't give it back unless you come back to court. And in many places, you raise bail through buying a little insurance policy, essentially, where the bet is, just like the bet for the insurance company typically is that you won't get sick or whatever, you won't crash your car, and they make the money off your premiums. And the bail premiums work the same way. And typically speaking, people show up in court and they get their bail back and they leave a little bit behind as the premium, the payment for the insurance policy. And those, in most states, in 48 states, everywhere but Oregon and New Jersey, those are enforced by private bail bonds companies, which employ private bounty hunters to catch people who jump their bail, who don't come back to court when they're supposed to. And there's a lot of problems in that system. There's a great movie called Jackie Brown that if you haven't seen it, you should see it right away about that. But in Oregon, we have done away with cash bail in many, many cases, which is a great progressive reform. And so in Oregon, many people, according to lists that are drawn up neutrally by judges, neutrally without regard to particular people or particular cases, there's classifications of crimes in each of Oregon's 36 counties, and for the lowest tier, they kick you out on a promise to appear in court. And the promise to appear in court, as long as you abide by it, there's no more consequences. And that's called being released on your own recognizance. Then there's conditional release. And conditional release is supposed to be used in the majority of situations. And conditional release is being released to some kind of supervision, some kind of interference with your life on an ongoing basis by somebody who works for the state, called a release assistance officer or a release officer or other names. Some places it's done by deputy sheriffs. And the idea is that it's a little bit like being on probation without being convicted of a crime. You have someone who knows where you are, knows where you live, knows where you work, that you have to report to regularly, that might have to give you drug tests and other kinds of restrictions, because conditional release is not just release to a supervisor, It's released on a set of promises, a set of conditions. Number one, that you won't commit another crime. Number two, typically that you won't leave Oregon without permission from a judge as long as your case is going on. And then number three, that you'll make your appointments and so forth. Those conditions, those intrusions on your liberty, are available to people without cost. And that's why it's a more progressive reform than cash bail. So freedom is not just for people who can afford to pay to be free, in other words. And then finally, people who can't be released on their own recognizance, can't be released conditionally, are held, detained, until they see a judge. And only a judge can set the amount of bail, typically speaking. We did away, the trade-off for getting conditional release expanded was we did away with a lot of bail schedules. In other words, there used to be set amounts of bail for a lot of crimes that you automatically could post, and now a lot of the time you have to wait and see a judge to get bail set at a certain amount. And in Oregon, the bail premium is paid to the state because we don't have bounty hunters and we don't have bail bonds. They're illegal in Oregon. In Oregon, if someone's accused of a low-level felony, bail might be $10,000, and you post 10% of that, $1,000. And then as long as you're cool, you come back to court when you're supposed to. At the end of the case, you get $850 back. And you paid $150 for being free for that whole time. That is the highest and most severe level of supervision we have. Now, bail can be more than expensive than that number, but that's the principle. Any questions about that? And so I talk about release a lot and bail because that is the practical concern of most people being arrested. For most people living through the experience of being arrested, they aren't thinking ahead to a court case and prosecution and conviction and sentence. They're thinking about, I don't want to be under arrest anymore. And that will become your overriding need and desire if you are arrested, God forbid, that you want to get unarrested. And so these are the ways to do it. And the more serious the accusation, the more likely you have to wait to see a judge. They have to take you in front of a judge on the next business day when the court is open, basically. But that comes with an asterisk. When I say the next business day, I don't mean later the same day. So if you're arrested at 3:30 in the morning on Friday, you will see a judge Monday. That is a bad time to be arrested. Most courts cannot process you same day after a certain point in the morning. Yeah? So when someone is booked into a correctional facility, a jail, whatever, they're booked on certain charges. The jail lists that they're being detained for certain criminal reasons. And those crimes are compared to lists of, what I said, the schedules of crimes, the lists that are drawn up by the judges in each county and pre-agreed upon as pertaining to a particular release status. So certain crimes have release on recognizance, certain crimes have conditional release, certain have security release. Now, judges are free to change that. I should add that wrinkle too. They can make any case almost more or less serious on that system. But those schedules, those preordained schedules, apply before someone is taken in front of a judge. Only judges can modify them. So only a judge can say, I know you committed, you're accused of committing a serious felony, but I think you're safe on conditional release under these circumstances. So a lot of people who are accused of committing, serious sounding crimes that aren't as personally threatening as others might get their release modified. I'd say burglary in the first degree, burglary of a home. If it's not accompanied by a physical assault or a sex crime, burglary can often be reduced to a conditional release. And people don't have to post bail for that if they're not repeat burglars. That's just a random example that I've seen and proven in my career. Other questions about that? All right. So the next important thing to understand about the criminal process after an arrest is that police don't, quote unquote, press charges. Certainly not in Oregon. And private citizens don't, quote unquote, press charges. Citizens and police officers do not prosecute crimes. Crimes are prosecuted by prosecutors, unsurprisingly. And more to the point, criminal charges are filed, criminal cases are initiated in Oregon only and exclusively by prosecutors. It's true in the state system, true in the federal system. So the cop that arrests someone does not decide what they are charged with. And the charges that someone is being told they're arrested for and what they might be prosecuted for in court later can be very different. And most often, the number of charges can expand, but also oftentimes officers are overzealous, and they might write somebody up for 5 or 6 crimes, but the prosecutor thinks they can only prove 2 or 3 out of the same incident. Yeah?
When I'm being arrested or even detained, does an officer have to explain to me the probable cause or the reasonable suspicion that they're using to take that action?
No, they don't. Yeah. Generally speaking, you have to have your charges explained in court, and you generally will have your charges explained for practical reasons in being booked into a correctional facility. Many times officers will choose to relate charges or potential charges in a way that's psychologically coercive, and they'll talk about charges that could be brought, but they aren't the ones bringing the charges. They have to be brought by a lawyer, by a prosecutor. And so I'm trying to not, give necessarily so much of a civics class about how our court system works here, as I am to talk about what practically happens to people who are arrested, for people who don't have contact with the criminal legal system and don't know what it's like. So then, somebody who's not charged with a crime, we're not going to talk about that path further right now. We can talk about things like sealing arrest records if anyone's ever curious on another occasion, but I want to use the time we have. So I think
I just had a quick question. You were talking about Miranda rights.
Yeah.
What if when they ask if you understand them, you say no?
Then they will probably try to read them again, or if you read English, they'll try to get you to read them. Or if you read another language, if you speak another language, they should bring in someone who speaks that language or bring in an interpreter. Amanda?
They carry Miranda cards with them to read from them, but do they have it available in other other languages?
Generally not, except for Spanish. Generally, they have them available in Spanish in Oregon. But not everyone is as good as reading Spanish as everyone else. And not certainly, that's another rabbit hole. So I'm going to truncate a lot of the discussion of the criminal prosecution system beyond here, because we started about 5 minutes late, so I should go until about 5 minutes. I'm good. All right, well, I'm eyeing the clock, thinking I only have 20 minutes and wanting to get to the protest stuff, so I just want to make sure. All right, cool. Well, I'm going to just talk about the other really important junctures in criminal procedure that might matter to an average person or supporter of a person charged with a crime, which is that if someone is being prosecuted, they have to go in front of a court for what's called an arraignment or initial appearance. And often those are handled by more junior, more specialized judges that only handle that kind of court where they process people in bulk. And those judges make decisions that are really just about one important question, which is release, which we were talking about a moment earlier. And so typically when someone's not been released, when they're brought in front of a judge, the three things you have to answer are, what are the charges, informing the person of their charges, getting their not guilty plea at that time to those charges, and addressing the question of release. And a fourth thing, you typically have to set another court date. And then after that, the salient part of the court process that I want to emphasize for people is after an arraignment and after release has been addressed, the court process will drag on an unseemly time. Our courts are very overcrowded. We have 38 judges in Multnomah County. 9 of them have to handle family law, custody, divorce, property, and probate matters. One of them is the head judge of the county. One of them handles coordinating the whole criminal court system. And that leaves 27 judges. And some of those have to do older cases, other things, civil trials. Some of them are on vacation, some of them are sick. And that's the most populous, numerous county in Oregon. In Washington County, in Hillsborough, we have 15 judges. In Clackamas County, Oregon City, we have 13 judges for the whole county. And these are very big, they're the biggest counties in Oregon. And it goes downhill from there. And so there is a tremendous delay built into the court system, and that is the number one complaint people will have who are processed through that system, is they have to go to procedural and interstitial court appearances and waste their time with their family, their time at work, anything else they want to do personally, sitting in court or making up for the time they spent sitting in court. So be aware, if you are supporting a person through the criminal legal system, one of the best things you can do is cover their other responsibilities while they're in court. That's something people can do without having to pay money to do it, in a lot of circumstances. So we aren't going to talk a lot about punishment and sentencing tonight, because that is typically a feature of the talk that I give at Paideia, but I do want to focus on some of the issues related to your rights and protests and your criminal procedural rights there. I do want to say that, generally speaking, most of the things Reedies get arrested for don't have very severe punishments in the Oregon state criminal system. People who are unlucky enough to get involved with federal law enforcement, the story is very different. Most people accused of federal crimes are convicted at a very overwhelming rate, and most people convicted of federal crimes go to prison or at least the detention of some sort. It's a very grim, very serious system, and I'm happy to talk your ear off about it if you want. The Oregon state system uses probation very heavily. For people who don't commit violent crimes or sex crimes or repeat serious property crimes like repeated burglaries, repeated identity thefts, repeated car thefts. Most of those people who aren't in those 6 categories are not ending up in prison in Oregon. Oregon overwhelmingly uses probation with small amounts of jail or fines or community service or specialized classes or specialized counseling as parts of the probation. And probation is, as one of the judges in Multnomah County always used to say, a list of things you have to do and a list of things you cannot do. And that is the reality of people who are living sentenced in the criminal system in Oregon. And one of the things that you can also do to support people who are in that system is not make them accidentally violate the rules of their probation, because they're the ones who may have to pay the penalty for your misconduct around them. And be sensitive and be willing to have a conversation with a person who's on probation about what they can and cannot do, and don't cheat or fudge around the edges, because again, like you don't get punished for that, they do. So if you need to deal with this system, you're going to want to have a lawyer. The knowledge that it took to get me to this point, I've accreted over not only 20 years in practice, but 3 years in school, of which 2 years I spent as a law clerk at the Federal Defender's Office, years of formal training programs through the public defenders when I was working for the county public defenders, and a requirement to continue to self-educate every year and prove that I've done it to the bar's satisfaction for the last 17 years that I've been in private practice. And I still, have a lot of struggles with my own adequacy in this job. It's a very overwhelming and daunting proposition to understand the criminal legal system fully and to understand how to apply it properly in different moments. So do not try to handle it without a lawyer. You are specialized and wonderful kinds of smart as Reedies. That does not mean that you have had this kind of training. Law school is less for people who want to practice law and not be professors. Law school is less graduate school and much, much more career technical education. I've been to graduate school and law school, so I can say that, because I studied to be a history professor first before I went to law school. And so it is night and day. And you want a mechanic to fix your car, you want a lawyer to fix your legal case. You really, really do. The best ways to relate to a lawyer are to be honest to them, first of all. And even in these very perilous times that we're in, attorney-client privilege is real. There's been no mechanism to successfully disrupt attorney-client privilege on a systematic basis in my career. There have been a couple occasional instances of jail visits being recorded. Those cases all ended with serious problems for the prosecutors involved and exoneration for the defendants involved. Those cases are very rare. And generally speaking, I have absolutely free phone, email, in-person contact with my clients on a variety of very sensitive topics, and I rely for their protection on the Constitution, on a paper shield. Attorney-client privilege has been proven to be real in my experience, and I believe in it. So that means you have to be honest to your lawyer. Yeah?
So you said that when you show up and they take you into the place and you say, I want a lawyer, they won't just send one to you.
No. You get a lawyer.
How do you get the lawyer there?
Sure. If you hire a lawyer, one can come to you, and sometimes even in police questioning settings, I've done it. And if you wait to have a lawyer appointed, you will meet with a lawyer when their schedule permits it after their appointment. And their appointment will happen on the first court date, typically, that you have. Some asterisks for the current public defense crisis in Oregon in some cases right now. But the appointment will happen when they have time after their staff has processed your case for intake. It will not happen right away.
But do they let you, on TV they talk about the phone call. Do they actually let you call your lawyer?
Yes, they absolutely do. And in fact, in DUI investigations, they have to, by law, provide you with privacy for a phone call before you can be forced to take a breath test and have the results used against you. And that's a special law for DUI cases. Generally speaking, there's no law that says they have to let you have a phone call in Oregon in other cases, but they generally will in most cases if they want to talk to you badly enough. But generally speaking, if you can't reach a lawyer right then because it's the middle of the night, you're SOL.
But you can call like your best friend and say, call my lawyer and send them down.
Yes, and it works with varying degrees of success. Generally speaking, that does not result in a physical face-to-face meeting, but it can, under Oregon cases that have been decided by the Oregon appellate courts, it can result in a lawyer making a phone call that can result in the suppression of evidence. For example, I got a call that a friend's son, my boss's son from a pre-law job that I'd had, was being questioned by police out in a rural forest in Washington County. And I called the Washington County non-emergency dispatcher, and I read them a prepared statement saying that I represented this guy, and the parents had hired me over the phone, and I was going to go out there and talk to the cops, and I wanted to find out where they were, and I wanted to stop the questioning that was going on. That was effective. Even though I didn't actually even talk to the cops on the scene, I communicated to their agency that a lawyer was involved in that specific case. That is rare that works that well. That's an example I can cite and a story I can tell. I remember years later that happened in 2013 because it's a rare, extraordinary case of it working out like you might think on TV. Generally, you find out about what's happened days, weeks, months ago as a lawyer. You find out about what the police wrote down or filmed that happened, and then you have to figure out a theory for dealing with it retrospectively. That's what really typically happens. Okay, so it's important to be honest to a lawyer for the same reason it's important to be honest to your doctor. They can't give you good advice unless they know what's actually wrong, no matter how personal or embarrassing it seems. It's also important to keep your appointments with lawyers or cancel them. Just not being flaky is very helpful for maintaining and protecting the relationship. It's important to do your part to protect attorney-client privilege. If you have documents that are sensitive about a case, if you're having communications where your lawyer's on the other end, your lawyer is keeping what you say secret, but your housemates may still understand what you're saying and it may be bad for you. You have to protect the privilege on both ends of the phone call or both ends of the communication, whatever it is. Don't leave legal papers where other people can get into them. And also, remember that lawyers are extraordinarily expensive, partially because they have extraordinarily high overhead. It doesn't all go into the lawyer's pockets typically. And many people qualify for public defenders in Oregon who don't think they qualify. People who own homes qualify for public defenders. People who drive nice cars qualify for public defenders. Because it depends not only on assets, but it depends on income versus debt versus assets. And generally speaking, public defenders in Oregon are very well trained and qualified, compared especially to the stereotypes of public defenders that prevail nationwide. So I want to pivot and spend a few minutes talking about some legal considerations that have to do with current events and the fact that we have a nationwide protest movement building again, maybe even a bigger one than we've had during some of the previous wars and other movements that people may have had experience with in their lifetime. But if people have questions about criminal procedural issues that I've been just discussing, I'm happy to talk about that as well. Yeah.
I have one more. Is there value in recording an interaction that I have with law enforcement, like me personally, not necessarily depending on their body cam?
It depends on the circumstances. I can't give you a really general answer to that, but I will say that under Oregon law, it's generally lawful to openly record conversations that are had in person. It's generally unlawful to secretly record conversations that are had in person. There are some exceptions, but generally they don't favor the citizen. Oregon only requires one person to consent to record a phone call. You don't have to actually tell the person that you're recording their phone calls in Oregon, but it requires two people to consent. And by consent, I mean you put out a recording device, the person has the freedom to walk away from it. They don't really have the freedom to turn it off. But in person recording your conversations without consent is actually a crime in Oregon. It's one of the invasion of privacy crimes. Again, only enforced against private citizens, Other questions? That's a good question. So the number one thing, yeah.
Oh, with recording, you mentioned that requires the consent of one person. Like, if I'm on that phone call, I can be that person, right? Right.
That's what I'm saying.
Yeah.
It always sounds weird when you say one party consent. I mean, it posits. There's not no party consent unless the robots are better than we think. Amy.
So if I'm pulled over and the cop asks if they can search my vehicle and I say that I do not consent, I've heard from some people that can then be used against me in some way that I don't know. I don't want to say it's probable cause, but
it's folk
it could
wisdom
escalate
that it can be
the situation.
Emotionally, it can escalate the situation. That doesn't mean that legally it escalates the situation. I mean, that's absolutely good that you bring that point up because it's something that I try to cover each year, and I hadn't mentioned it explicitly yet. Exercising your rights is not evidence of a crime. And Oregon courts really care about that. And people invoking their rights does not add to the calculation of probable cause. It doesn't make you more suspicious that you want to rely on what you're guaranteed as a birthright, as a person who's in Oregon, Whether you're a U.S. citizen or not does not matter to the Oregon Constitution. If you're here, you're protected by the Oregon Constitution. Your birthright as a human being, I mean to convey. Anyway, does that answer your question? So I want to go back to something that a person in the audience asked me a while ago, and I said I'd get back to, which is digital devices in protests. Because we are approaching a moment where mass participation may be needed to cause needed social change. And for political reasons, for organizing strategy reasons, and for protection from criminal law reasons, the best safety is in numbers. And one of the worst things I think people can do in this moment is try with a good heart, with good intent, to gatekeep protests and to make it sound complicated, technical, specialized, daunting, intimidating to go to protests than to participate in voicing your dissent. And that is dangerous. It's dangerous because it makes protests seem like what people go to if they belong to a particular club. But it was one of the, I think, shortcomings of mass protest throughout both the Occupy era and the summer of 2020. And I was a lawyer for people arrested in both of those times. I was one of the lead lawyers for Occupy Portland in 2011 and 2012, and the occupation of downtown that happened then. And I was also a heavily involved participating lawyer for people getting arrested and charged in federal court with trying to attack and vandalize the federal courthouse in the summer of 2020, for very good reason, that a lot of people had to want to do that kind of thing, but they got in trouble for it. And so I say this not as somebody who's unsympathetic to people who are protesting in the streets. I personally have to stand at somewhat of a reserve because I'm more useful as a force multiplier. I'm more useful behind the scenes, given my specialized training and experience and my ability to do things like go in and out of jails and go in and out of police stations, which I have to stay arrest-free myself to keep. But generally speaking, I'm in a tiny minority of people who are like that, who are unfortunately sidelined by their careers. Generally speaking, there's safety in numbers, and if there's nothing else I can tell you that relates to the rest of this subject of this talk, there's nothing else I can tell you about protesting and organizing and what might be happening next in the United States. It's that you shouldn't try to turn people away by making it sound overly technical or complicated to go to a protest. And that includes not having too many rules about faces, masks, makeup, clothing, devices, signs, slogans. Not really caring about how other people protest is probably the pro move here. Because, as I said, there's 13,000 FBI agents for the whole country. The DEA, the ATF, Homeland Security Investigations, the Border Patrol, all the other federal law enforcement agencies, they're all smaller than the FBI. The Portland Police has 900-odd sworn officers, of whom a number are administrative or specialized. They do things like training. They only focus on certain kinds of cases. They are detectives, or they're focused on higher-level cases. Only a certain number of officers are on patrol at any given time. They're divided up into shifts, obviously. People are sick or on vacation. And so there's only a couple hundred cops in Portland at a time. Multnomah County, they have their own level of cops, but they're stretched thin doing a number of other missions. The state police, all of these agencies have limited numbers when it comes to people in the streets demanding change. The worst thing you can do is to reduce the numbers confronting the police. And that's why I harp on this point so hard. And I appreciate the chance to be able to make it. Because at some point, the president's approval ratings are going to be in the 20s. And he's going to try to invoke the Insurrection Act or try to declare martial law. That might well happen. And when that happens, the proof I've seen as somebody who studied history at Reed and in graduate school is that the only thing that saves people is having absolutely overwhelming numbers in the streets. Numbers that are too big for law enforcement to process. And numbers protect people by making it less likely that the average person will be stopped or interacted with by police. They do not protect everybody. That is obviously a significant point. You are always taking some level of risk by participating in organized protest activity because some marginal number of people will be screwed with. But the bigger you can get the protest, the less likely it's going to be you or the person you care about. And that's not trying to give selfish advice. It's trying to give pragmatic advice, if that makes sense. I also think it's very important to have a clear strategic purpose for taking risks being out in the streets. And that's something that I say as somebody who's participated in protests, done legal observing, done protest representation over the years, and is a Reedy who cares about politics and is a criminal defense lawyer, that A lot of people get burned out doing the same thing every night and bashing their head against the wall. And that was the problem, marching night after night in 2020, having the same encounters with the same police. People have a lot of trauma from that and a lot of memories about how they think they could do things better from that. But it doesn't question the fundamental assumption that marching in the streets is always what's needed, that going to the courthouse, the federal courthouse every night is always what's needed. So I hope that people would have a clear strategic purpose for resistance activity, and acting with a clear strategic purpose is more likely to not cause you to need my services. That's the criminal law tie-in to all this. And it's also important to worry less about infiltrators or provocateurs. It's not that those people don't exist. It's important to have some level of vigilance. But again, don't gatekeep people who would help sincerely because of judgments about their past. What's happening and what may have to happen next is going to take a coalition of people who are disillusioned with what's happening in the present, and what they did in the past, who they voted for in the past, for example, is a lot less moment than what they're willing to do in the present, because maybe their eyes have been opened. So I would encourage people to have a welcoming atmosphere. And decide now what you won't tolerate. Start planning for how you'll respond if it seems about to happen, whatever your line is, whatever you won't tolerate. And I would encourage you in all your efforts to be mindful of security and clear communications, but also of efficient decision-making and strategic thinking and learning from the experience of yourself and others, and not constantly reinventing the wheel. And hopefully that leads to a more creative attitude toward encounters with law enforcement as well. So I'm right at about the original scheduled time. I'm more than happy to answer more questions. I have more thoughts about protest and organizing that I've written out over the years, but I won't give you the whole dissertation right now. So thank you very much for letting me tack that on to the end, and feel free to engage me in any of the subjects here in the open forum, or afterward, just approach me and I'll stay around for a while before going to dinner, and I'll be very glad to talk some more. Thank you. And let's have some more questions for sure.
Just a really, really quick question. Do you know where I could get a red card for an immigrant who's overstayed her visa?
I can give immigration law referrals privately. You're welcome to contact me using the info on my business card, and I can connect you to an immigration lawyer who is a Reedy who I trust.
Okay, thank you.
In the back with the mask.
Oh, I was just going to say that at the county library, red cards at the county library. There may be a gap in them, but there'll be more coming.
Thank you. I didn't know what that person was talking about, obviously. I thought you were saying something else. Thank you. Yeah.
So earlier you were talking about getting this thing off the Constitution. Oh, sorry. So earlier you were talking about in Oregon it took a lot of work to get rid of this part of the Constitution, or get rid of this exception.
Yeah.
And stuff like that. So how do we learn about what that work looks like, and who's doing it, and what's happening now? And
Well, if there's not a course in legal history, legal history is a great class to take that people sometimes have in college environments as well as law schools, but you probably have to do some self-directed reading, and I'm always happy to suggest things. To get to a level where you can appreciate the court cases isn't that hard. It doesn't actually require going to law school. It's one of the first things you do in law school. Court cases are designed to be accessible to a person of fairly average intelligence. When they're not on specialized topics, they're often surprisingly readable. If you get into specialized topics that are highly regulated, like financial laws and tax laws, they're not necessarily readable. But just you might have a better chance reading your friend's history thesis than reading a math thesis if you're not a math major. There are certain disciplines that are just more accessible in their prose, and a lot of criminal procedural opinions are pretty accessible, but learning how to find the ones that matter is the trick. That's the one where you have to have some kind of training or guidance, and I'm always happy to talk about that kind of thing. I loved taking legal history in law school because I had already been to college to read for history and then to grad school for history. And so I did a bunch more legal history work in law school. And I will talk your ear off about the history of the American and the Oregon legal system, and specifically about independent Oregon state constitutional law, which is following Justice Lindy and Justice James is a particular hobby and habit of mine. Others? Yeah.
You mentioned the Insurrection Act, so I guess this is kind of an unanswerable question, but
Generally speaking,
Bear, could you repeat that question, please?
yeah, what do you do if it seems like the fundamental constitutional assumptions of our system are being undermined? Generally speaking, that is one of the red lines that should force people to overwhelm a government through numbers. That has been proven true in the peaceful revolutions in Eastern Europe, in several countries, in several circumstances, with several local variations, and in other parts of the world as well. And generally speaking, the criminal legal system is not going to be functioning as well in the presence of really brief, temporary, mass revolutionary action. But, and when I say revolutionary, I do not mean with weapons, parenthetically. Absolutely anything we can do to change government in this country can be done without weapons. And it's always best to let the other side be the first one to stain their hands with violence. But generally speaking, the terrain that's being contested is not the criminal legal system of Oregon that I've been talking about in this talk. And I have skipped over a lot of material that used to be the connective tissue of this talk because a lot of it originally was about drugs, right, for practical reasons. So shifting the focus to political organizing and activism necessarily makes it seem a little more disconnected because the drug topic clearly tied into the state court system. But generally speaking, if we're going to a mass protest model, the state court system is only going to process those marginal people, as they said, who are just scooped up because they happen to be the fish close to the edge of the pond. And it's probably going to function pretty normally, just slowed down. I say that because it functioned pretty normally, but just slowed down in 2020 and also in 2011. And also 2003 when I was a law student and I was observing protests for the National Lawyers Guild. That's what happens when we have mass protest waves. Other questions? All right, thank you. You've been very attentive.
This will be the last question, I think.
What techniques or words have you experienced through your clients that law enforcement will do in a stop or a detention to get people to give consent without them realizing they're giving consent?
Well, generally speaking, they realize they're giving consent. It makes it sound like the path of least resistance or like it's going to help them. Typically, there's a wide variety of tactics, but I would say there's one set of techniques that are focused on make the current unpleasantness stop, and there's one set of techniques that are focused on this will help you down the road. Because you see, police are allowed to lie. Both the state and federal systems have no problem with cops lying to do what they want. And they're allowed to lie about your rights, generally speaking, except for Miranda warnings. They're not allowed to lie about those. But they're allowed to lie about other aspects of your rights, including, they're not your lawyer. They're not there to help you tease apart whether you can lawfully be searched or not. And they will say that it will get you favorable consideration with a prosecutor, that you were cooperative, that you didn't make them work too hard. That is not necessarily true. But they also can say, we can do this the easy way or the hard way. You can let me look in your phone now and I'll just write you a ticket no matter what happens. Or you can insist on your rights, play tough guy and go to jail. And then we'll see what happens later. And people, a lot of the time, do not want to go to jail. And they think that trade-off is real. It could be that they weren't going to go to jail till the cops saw something in their phone. They could have been lying about taking them to jail. You see, there's innumerable scenarios. All right, and it sounds like that was the last official question. Feel free to hit me up for more individually. Take my business card, contact me by phone, text, email. I'm very happy to talk. One of the things that I think sets me apart from other lawyers is not that I'm particularly smart, but that I like to talk with anybody. And I'm very accessible. And I really pride myself on being available all different times, day or night, all kinds of circumstances when it's necessary. Thank you so much.
Thank you very much, Bear.